Presidential Petition number 1 of 2021, Kyagulanyi Sentamu Robert, the petitioner, versus Yoweri Museveni Tibuhaburwa Kaguta, the Electoral Commission, the Attorney General for the respondents, before the Honorable Mr. Justice Alfonse Chigamoy Owiny-Dollo, the Chief Justice, Honorable Lady Justice Dr. Esther Chitimbo Chisache, Honorable Lady Justice Terra Aracha Amoko, Honorable Mr. Justice Ruby Opio Aweri, Honorable Lady Justice Faith S. Monda.
You are all aware a presidential election petition is one which, by the Constitution, the Presidential Elections Act, and the rules, must be determined expeditiously and within specific time frame. The court has no power to expand, it has no latitude to expand this time frame. Beginning Tuesday the 2nd of this month, last Tuesday last week, we must determine this matter within 45 days. It is really, really important that we abide by this timeline, because we may end up with a crisis. We have to apportion time for each stage, for each action in the process. We have to give it reasonable time. The law gives what it considers reasonable time, 15 days, within which to file a petition when one is aggrieved. The law gives very limited time frame for response by the respondent, 3 days, whereas in the ordinary civil matters, one is given 15 days. For a presidential election petition, it is 3 days for the response. For the response. It's 10 days today since time began running. We've used 10 days out of the 45 days. Lord Council Obega, the petitioner was expected to have filed affidavits, either together with the petition or soon thereafter. You've utilized 10 days. I have not seen one, unless you filed one this morning. But we count the period. You ought to have filed affidavits as your time. Accordingly then, if we are to fulfill the legal requirement prescribed in the Constitution, the Presidential Elections Act, and the rules made thereunder, we give the petitioner an additional period of up to Sunday the 14th, that is this coming Sunday, to file all affidavits. So beginning today, up to Sunday 14th, the petition is expected to have filed all affidavits. That gives you the benefit of about 14-15 days from the date you filed the petition. The respondents, and I'm going to guide you on how service will be done. The respondents on whom service would have been done already have up to Saturday the 20th of this month to file their own affidavits. The petitioner will have up to Monday 23rd this month to file any affidavits that may be required in rejoinder. On the 24th, we will continue with the process you are not able to conduct today. The prayer you were making, Learned Counsel Obega. You will then have sufficient time to have discussed, to have had the benefit of the various affidavit evidence from both sides, or from all the sides, and present to this court on the 24th of this month the scheduling memorandum, which would indicate what you have agreed on, what are your points of divergence. Then we arrive at the issues for determination by this court. But I need to point out, and I particularly appeal to counsel for the respondents. There is absolutely no reason why the petitioner must apply to court for discoveries. If there are any documents in the possession of your clients which the petitioner wants to use, they should be availed easily. There's absolutely no reason why counsel must have to apply to court and court has to give an order. In the interest of the due process, I expect Counsel Obega and your team liaise with the Attorney General, who is the lead counsel on the other side, so that if you need any document from any of the three parties, it should be availed. Then if there are difficulties, then the matter can come before us. So when we are done with the pre-hearing scheduling, the trial, on the 24th, then we will proceed to written submissions. Written submissions is going to be a major component of the hearing. The petitioner will have up to Saturday, the 27th of February, to file their written submissions. The respondents, all of them, will have up to the 2nd of March this year to respond, and the petitioner will have up to March the 4th for any rejoinder that may be necessary. Then on Friday the 5th of March, the court will accord learned counsel for the parties the opportunity to make oral submissions strictly for purposes of highlighting. Strictly for purposes of highlighting, not again to come and cover the entire submission and internalize whatever you'll put down. So, counsel on both sides, you are a responsible person, you're led by senior learned counsel on both sides. You know what material court needs to make your case. You know what material court needs to defeat the case put by the other side. Please do not meander all over the world. Do not bring us volumes from the floor to the ceiling. We really need to know what you have in your arsenal to make your case. I believe counsel understand what I'm saying. And on that 5th of March, your submissions in highlighting will be for 30 minutes, strictly 30 minutes. When your 30 minutes clocks, the Chief Justice will have the unpleasant duty to ask you to sit down. And then rejoinder would be for 20 minutes, and that will conclude the hearing. Before that, on the 25th to the 26th, court would avail you the opportunity to cross-examine witnesses that you would have notified court, and counsel for the other side you intend to cross-examine. Court would avail you the opportunity to present whatever electronic evidence which you would have applied for, if any. Then subsequently we go to the highlighting of the oral submissions I've already talked about.
I beg your pardon, my lord, on the date for the visual electronic evidence.
Yes.
On the date, my lord.
Come again?
Yeah. I beg your pardon on the date when that electronic evidence may be presented.
25th to 26th.
Also like, my lord.
Yes, of February. There are 2 days for cross-examinations and for receipt of any electronic evidence that may arise. And as I said, 5th, we'll have the oral highlight of written submissions already in court's possession. The court will then retire and use the duration of 7th to 18th, which I think is 10 days, to write its summary judgment to be delivered on the 18th of March, so that we are within the 45-day period. As you can understand, if you disturb this schedule, we'll run into problems. We've given you sufficient times. We do not intend that the little time we have given court to avail you the opportunity to present your case should be eaten up more. So everybody will do everything that needs to be done to ensure that we keep within this time frame if we are to render justice in the matter before us. Whatever deficiency the court of law may have, it is an institution. You don't want to go back. We have seen the alternative to a court of law. So in whatever we do, because we love our country, we may differ, even on points of law we may differ, but it is the duty of counsel, it is the duty of every Ugandan to strengthen the court of justice and ensure that it properly contributes to the stability and economic development of this country. There is no alternative. Thank you. Yes.
How can I have spoken to them? No sooner had I sat down than they showed exactly. Yeah.